Welcome to our podcast, Hot Topics in the Workplace, when medical conditions arise, impacting someone's ability to be at work, stay at work, and perform the work. And so here with me today is my co-host, Felicia Amenta, workers' compensation consultant and specialist. Thank you, Felicia, for being here with me today.
Oh, you're welcome. It's my pleasure.
Great. And of course, I'm Dr. Debra Dupree. I'm the IPM facilitator and workplace mediator. And so we generally will pick 3 or 4 topics to each podcast and dive deeper. And using both case law, case decisions, but also bring to you some local examples. And so let's get right into it here. Just a quick overview. We're going to talk about 1 employee, 3 doctors, different answers. When full duty isn't the full story, what happens? The next one, the hidden risk in workplace accommodations. And now this is where we can actually be too rigid. And then thirdly, the accommodation tightrope. And this is where an interesting case where attendance at work can be considered an essential function. And I know we've struggled with that whole remote work kind of topic, particularly through COVID and after. And then the last one, can you really ask that? Just how far can we go when it comes to understanding the impact of someone's medical condition on their ability to be at work, stay at work, and perform the work? Okay, let's get going with number 1. 1 employee, 3 doctors, different answers. When full duty isn't the full story, what do we do? And this is actually a local case, Felicia, where it's actually in progress, but just some very interesting dynamics. And I know we've had a chance to talk about this because I've leaned into you for what do you think here, as has the JPA. And what's really interesting here is that sometimes in these cases, we do get multiple doctors. And then under workers' comp, there's sort of one way to go, and that's usually with the treater. But ultimately, in finalizing the case, if there's a qualified medical examiner, then the case gets settled more or less on the qualified medical examiner's findings. But in this case, these injuries go back to 23, 24, and 2 different sets of injuries. And then there's some secondary symptoms that have gone untreated. And the district's really done a great job in trying to temporarily accommodate, but to the point of where, let's just say, way overboard. And for a lot of reasons I won't go into, but best practices are really temporary accommodation of 60 days, maybe 90, followed by 60, maybe 90, depending upon your local agreement. Because if somebody is not improving during that time, that's actually an indicator that continuing to work is not in their best interest and recovery. Otherwise, we know that continuing to work oftentimes does facilitate recovery, and we see people actually improving much faster. But if somebody's static or even worsening, then pull the plug. You have to get the person off of work, let them recover, let them focus on their medical care and so forth. And I guess, Felicia, I just want to tap into you for a moment. I'm sure you're quite familiar with this kind of issue, right?
Yes, we run into this a lot. And it's so interesting because the rules in workers' comp are quite rigid when it comes to multiple doctors. We really look to the QME or the AME exam as the CEO of all of the case, and they supersede everyone else. But the QME and the AME only have one time to see the person, and they're really relying on a medical record review and then maybe 30 or 45 minutes with the individual, versus you have all the other physicians, the primary treater, the secondary treater, they can refer them to different specialists, maybe orthopedists or pain management doctors. You might have 3 or 4 other physicians treating a complex case, which this one is. And they all have differing opinions about, one of them might think the person can return to full duty work. One of them might think the person needs these work restrictions temporarily. Someone else might find these restrictions and find them permanent. And so it's much more difficult to navigate the disability management than it is to just for workers' comp to say, whatever the QME says, that's what we're going with. That's the end of our discussion.
Yeah. I think we may have talked about a similar case in one of our recent podcasts, in that I had another individual, again, wants to return to work, but she's, every time she returns to work, she has increased symptoms and she gets taken off again. And she actually she had surgery. This is upper extremities. And she got her surgeon to say she could return to full duty. That was for one arm. She also has an
Mhm.
injured left arm where she has significant limitations. And so, again, this is where we had different doctors for different body parts who had conflicting opinions. And that's where I brought this case up today because, yes, we have the treating physician who says full duty. But interestingly enough, full duty only came after she was off of work for several months due to a totally non-work related matter. And that's the only time she saw improvement. And so when we first met in the interactive process about 3 months ago, she had significant limitations and yet was claiming she had improved. I get it. You improved a lot. Great. You still did your physical therapy and you weren't working. So I get that, but you had to have a medical doctor. The pain management specialist was a little more reticent about saying full duty. It took a little longer, but yet the treating physician still said she still had not declared her at maximum medical improvement. This doesn't make sense. And so, okay, we got it. And so she was provided with temporary alternative duty. And then coming back, she got another statement from her treater doctor saying full duty, but still not MMI. It's something's not connecting. And so this is where it's really important that full duty is one thing, but again, have they reached maximum medical improvement? Because usually they go hand in hand, right?
Yes. You can be released to full duty before you're declared maximum medical improvement, right? Frequent people will have, let's say, a rotator cuff tear, or they'll have a knee surgery, and they're released to a trial of full duty work. The doctor wants to see that they can handle it before they make them permanent and stationary and do their permanent impairment rating. So we see that very often, that they're released to a trial of full duty work, and then that's their status, and then they'll go on and do an MMI report. I think what you and I find one of the most difficult questions is employers or districts, school districts who will say to us, what doctor's note do we use? And I say, we consider all of them, all of them. That is not the workers' comp answer. They will say, we only care about the QME's work status, or we only care about the AME's work status. But that is not the answer in disability management. And it's not so simple. And they were like, yeah, but then there's 5 pieces of paper, 5 different doctor's notes on the table. And I said, and then that in a combination with the IPM is trying to take a look at a puzzle, right? Which is the most current note? Which is the doctor that's treating the most body parts? Because sometimes you'll have one note for, I just saw a case last week. They have one set of restrictions for their neck, and they have a different set of restrictions for both of their shoulders. And I'm like, all of those come in. Those are cumulative notes, right? So that's the thing that's difficult about the multiple notes. You'll get an answer from your claims team that is not an answer for disability management, because the rules in workers' comp about the notes and the work statuses that they consider most reliable and that they rely on for stopping benefits or starting benefits don't have anything to do with the disability and EEOC and ADA and FEHA. And when you start having multiple notes, you and I also go back to, how long have they been on temporary accommodated duty? Because if they've been on temporary accommodated duty longer than 6 months, I know we talked about a case a couple podcasts ago. I think the person had been left on temporary accommodated duty, that gentleman, for 2 years, right? He just got left there and nobody met with him, and they didn't have a written policy. And then when he was declared MMI and had permanent work restrictions, they were like, oh, we can't permanently accommodate. You have to go home. And then the fireworks started with the union and with everything else. So it's better. And I think even the EEOC doesn't require temporary accommodation for longer than certain periods, right?
Yeah, the federal guideline has long been up 6 months max, because beyond that, we're probably talking about a long-term medical condition. And and I think we both have seen that when we have had those kinds of situations of where the limitations have not changed over a period of time, they typically do become long-term limitations. And so again, using the IPM as a great risk management tool, and keeping in mind under ADA and FEHA, we've got to take the global picture of the medical situation, not just the workers' comp doctor managing the claim. So, yeah.
And I think it is difficult because a lot of times the claims team will say, we're either going to cut off benefits, right? We have one full duty release. We're going to stop benefits. But that doesn't mean that the team that's meeting with the IPM, that's not the rules that they're going to go by. That definitely shouldn't be what's making their decision, especially if they have 4 other notes saying that the person cannot return to work full duty.
Yeah. So what's next? Right now the plan is she will return to full duty and come fall, since this is an educational setting. However, if things still are muddy, then a fitness for duty may be put into place to evaluate the whole picture. So let's see what happens. I'll keep you posted. Okay. Yep. Okay. Moving on. The hidden risk in workplace accommodations when workplace practices are too rigid. And Felicia, I know that you've got a DOJ case that's considered a landmark case against a well-known telephone provider, cell phone provider. Let me take it away.
Yeah, this is an EEOC case also. This is a major employment rights case that Verizon just settled. They agreed to pay $20 million to settle a nationwide class action disability lawsuit involving the ADA that was brought by the EEOC. This is the largest settlement in EEOC's history for a single lawsuit. And EEOC charged Verizon with violating the ADA by refusing to make exceptions to their no-fault attendance policy for employees whose absences are due to disabilities and medical conditions. Under the Verizon policy, any chargeable absence, regardless of the cause of the absence, could trigger progressive discipline up to termination. And the EEOC argued that employees with disabilities who needed to leave work to manage their condition or to be off work to manage their condition were denied reasonable accommodations that led to unjust terminations or disciplinary actions. And the lawsuit covered hundreds of employees in multiple locations that were either disciplined or fired under this policy. So the decree that went along with the settlement, Verizon has to pay $20 million in monetary relief that goes into a fund for the affected employees. 2, revisions to their attendance plans, policies, and ADA compliance procedures. 3, reporting requirements to the EEOC on all their disability discrimination complaints related to their attendance. And 4, internal monitoring to ensure compliance. And then 5, the public notice of the settlement, meaning that it couldn't be a private settlement. And so that's why it's in the press. And if you look it up, you can read it right away. And the EEOC was saying that the case set a precedent that rigid, no-fault attendance policies that penalize all absences equally, even those due to particular disabilities, can violate the ADA. And it reinforces that employers have to provide reasonable, that accommodations got to be granted without penalizing them. And also this big settlement also talked about the importance of flexibility and with your company and also within the company, and that EEOC is pretty aggressively enforcing ADA leave and accommodation requirements, right? Because you can see what happened. They kind of lumped them in, you miss this many days of work, then that's, and the EEOC was saying that is too rigid and that is not okay, right?
Yeah. And actually, I don't know if the case actually addressed this, but by not, it's one thing to have an attendance policy, but then again, with anything, there's going to be exceptions. And so in this case, the medical condition will be the exception, because obviously if you're ill or injured or you're recovering from a surgery, you're going to need more time. And so one of the outages, it's never easy to have an employee off of work or providing temporary, modified, or alternative work. However, employer, particularly the bigger you are, it's doable. And that's why the EEOC has ruled in the past up to 6 months. Again, not easy, but be reasonable, be compassionate, and allowing people time to recover. And by not giving those exceptions, then it could actually be a discrimination against, which is another violation. So this is a big case, and
that was a big case. Yeah, so it was really interesting. There were a lot of interesting twists and turns that came out of that.
Yeah, absolutely. Okay. Now, this one is also related to attendance. And so this is sort of that balancing act, that tightrope comes into play. We certainly know we've had a huge increase of requests for remote work. And while remote work is always considered an accommodation with medical conditions, you also have to take a look at the essential functions of the job. That's the other part about it. And so this is where the EEOC actually said that when attendance at work is an essential function, versus remote work is an accommodation. So yeah, I know you've got some case details on this one.
Yeah, this case was so interesting. Last night I was going, wow, this really flips this is going to be a new case that affects a lot of things going forward. So you and I have seen so many cases since the COVID-19 pandemic where it forced employees to temporarily work from home, and that some employers have really struggled to bring their remote employees back to since return to work at a lot of employers. They wanted to go back to their usual. Some employees have asked to extend their flexible teleworking arrangements, sometimes by requesting remote work as an accommodation. We've seen it over and over, both in workers' comp and non-industrial disabilities. And these employees need to consider this recent decision. This came down on May 8th. So this is a real recent Fifth Circuit Court. It warns that the COVID pandemic did not change the reality that in-person work is presumed to be an essential function for most jobs. So Albert Hayes was an IT systems administrator for GSTEC, which is an Army contractor. Hayes was allowed to temporarily telework due to COVID. But in February, like a lot of people, right? But in February 2022, the Army transitioned away from telework and he was required to return to work in person. And he claimed then to be overstimulated by the office. And 3 months later, he was diagnosed with autism, major depressive disorder, and a social anxiety disorder. And this was fairly serious. After completing intensive inpatient psychiatric care, he requested reasonable accommodation, supported by a doctor's note, asking for telework. Initially, GSTEC was inclined to grant the request, but the Army, who is their contracted client, said it would not be in the best interest to allow full-time teleworking. And GSTEC yielded to the wishes of their client, and they gave him permission to work a hybrid in-office and remote schedule. And we've seen this a lot, that a lot of the school districts have navigated this way. And he claimed in his limited time in the office that this caused him to have a mental breakdown. That's what happened in this case. And he and his doctor agreed he could only work from home. And GSTEC terminated him the next day. And then he sued. He sued GSTEC for disability discrimination, and they failed to reasonably accommodate his disabilities, right? And we've seen this too, right? Oh, yeah. And so the trial court found that GSTEC had reasonably accommodated him by allowing the hybrid schedule, and that the appellate court also concluded that in-person attendance is an essential function of his job because their client, the Army, had determined that teleworking full-time was not in its best interest. The court said that allowing him to telework full-time would open the floodgates to all employees' requests to telework, and it could damage GSTEC's contract relationship with their client. So this case is a reminder that employers can consider factors like supervising an employee, communication with an employee, and customer preference, right? When determining if accommodations are reasonable. So this case turns this on its head in another direction than what we've seen, right?
Yeah. In fact, I had a case where, again, somebody had been accommodated through remote work due to what was anticipated to be a temporary condition. In this case, it was actually postpartum depression. And so had difficulty being away from her young child. And so the education facility worked with her, but she was also a mid-level manager overseeing employees and was directly responsible for supervising and directing the task of these employees, and also interfacing with other departments because of the nature of her position. And so they did temporarily accommodate her, but when she continued to request ongoing remote work, it was like, no, your essential functions do require you to be in person, to supervise and direct the activities of your employees. And when it happened, that, let's just say, some things happened because she wasn't there, and so got poorly handled. because there was nobody of authority for the employees to go to. And so that really raised a whole nother legal issue for the educational facility. And so this case really hit the button for me when I saw it, because it's, oh, yeah, good. Because if you're not at work to perform the work, given the nature of your essential functions, then you're not performing the essential functions. And that's where this is a good case, that it's a good example of where, yeah, remote work's an accommodation. However, what are the essential functions of your job? And can they be effectively achieved remotely? Because again, you have to be able to perform all the essential functions. And in my local case, she wasn't to the level of performance required, to the point where it led to other issues for the educational facility. Yeah. So this is going to be interesting. It's going to be changing a lot of remote work considerations for sure. Yeah. Okay, our last one. Can you really ask that? And this one really touches on the use of medications at work and how important it is to ask those tough workplace questions about medical conditions. And I like to always emphasize that's why we have the interactive process. It's to have that confidential setting, because employers and employees need to communicate about this when it impacts work. So we've got a case on this, EEOC versus right way ready mix. So this is an interesting one too.
This is a really interesting one, especially about the timing of when you can ask new. This is not an ongoing employee. This is a new hire, an applicant, right? And so I thought this case was really interesting when we were preparing for this. So the EEOC filed a lawsuit against Right Way Ready Mix and Right Construction, which are two West Virginia-based companies, for disability discrimination under the ADA. So per the EEOC, this was a job applicant, right? Not an ongoing employee, for a labor position at the Right Way facility. And the new applicant was asked by a hiring manager about the medications he was taking. He had not been offered a job yet. This is important. Okay, that's the important twist here. The new applicant disclosed that he was on methadone as part of a medication-assisted treatment for opioid addiction. The hiring manager told him the company would not hire him due to a longstanding policy banning hiring of any employees taking methadone. And the company's HR manager also confirmed that this was the company's policy. And then the lawsuit was brought by the EEOC under violation of the ADA, alleging that the company, one, asked about the new hire's medication before making a job offer under the ADA. They needed to make a job offer first before they had this conversation. Two, they refused to hire based on the applicant's disability-related condition, meaning that he was in a treatment plan for opioid addiction recovery. Also, can't do that. Three, maintained a company policy that unlawfully excluded people with disabilities from employment. And this EEOC action is part of a broader effort to protect workers in addiction recovery from employment discrimination. So that was the larger overarching issue that came down as a note on the bottom of the case as I was reading about it. But I thought it was very interesting because it's one of the things at many school districts that do pre-employment post-offer. They have offered the job, they have offered the applicant the job, the applicant has accepted the job, and then they may have a company policy where they require a drug test, a physical, a TB test. There are things that you have to do at some school districts per their district policy and their board policy. And they all have their own policies and rules and regulations on what they do. The TB testing is a state mandated testing. So that's happening. But the others that's employer by employer. But you do it after you have made a job offer and they've accepted the job. This one, they hadn't even offered the job yet. They just asked about it. So that was the misstep. So this one was interesting because it was a new applicant and it was the timing. And even the HR manager could have helped out with this, but they said, no, this is our overarching policy. We don't hire anybody on this particular medication, which this particular medication you and I know has often been used and is often used as an addiction recovery treatment.
Yeah. Yeah. There's two key points that I'd like to bring up about that because it has three actually. One is singling out for a particular condition or medication in this regard. So you're making an assumption about someone's ability. But two, as you said, is that you got to make the offer first before you discuss accommodation. And too often, I have to caution my employer clients to, in an IPM, is that don't just make assumptions that someone cannot do a job based on their limitations. Again, it's got to be an open position. Is the person qualified? They have to, be qualified for the job before you even start talking about accommodations. So don't put the cart before the horse. And so it's really important to follow those steps. And so we see that all the time when we're talking about alternative work or other considerations rather than the usual and customary job. And then the third point that I think is important to emphasize with this particular case is that the employee has to be in treatment for their medical condition when it comes to substance abuse. And in fact, I have another case right now again where there have been allegations about an employee, coming to work with Shelly, and to the point where she had a couple of coworkers that covered up for her and sent her home from an administrative standpoint before anybody got wind of it. But then a very public incident happened and basically defied the redirection from administration. And so she was taken off on a paid administrative leave while investigation was being conducted because it was like, what's going on here? She was making allegations about certain things which were causing her to drink. But then it turned out that she did provide substantiation that she was being treated, and so she's been off and now she wants to try to come back. But it's like, had you been treated for your condition? We don't even have any information to work with. If she goes, I'm going into treatment. Okay, good. It will meet after you get done with treatment before the start of the next school year. And because she could have been terminated by these behaviors in the workplace, but when it was supported by a medical condition, and that's where, okay, suspend that process and get involved in the interactive process. But she's been off work. It's been interesting. Multiple doctors from a particular facility, and then she's been estimated to come back to full duty, only be taken off immediately. So she never got back to work. So these could be complicated things.
Yes. Oh, yeah. I would say that this is one of the most complicated areas and where I really, certainly employers need to be cautious about how they proceed. Certainly many school districts have reasonable suspicious drug and alcohol testing on campus. And if you're at work and you're working with students or you're working on a campus and that it's reported or supervisors think or managers think that you are under the influence of either drugs or alcohol, you can be driven to a clinic and be tested immediately. And if you fail those tests, you're right. A lot of them say, okay, per our policy, termination. That's it. It's a no fault. It's a no tolerance policy, zero tolerance policy. And you're right. The caution is, okay, we're doing an IPM. Is there an underlying medical condition? Is there something going on? Could the person go into treatment, right? Or are they in treatment, or is this something they're working on? And where are they at with that? Maybe they need to be, and it's more complicated than just that, right? Oh, we got they have positively tested positive for drugs or alcohol. Okay, that's it. With no more steps need to be done. And
yeah. In fact, in this case, when I said she defied the district's direction, she was supposed to remain in the HR office, and somehow she slipped out and got a coworker to take her home. So they were going to do that, but then so there's a bunch of different issues going on in that one to be resolved, to be continued. So yeah, it's always such a delight, Felicia, to work with you on these topics, and what an interesting world we live in, right?
Yeah, absolutely.
Yeah. And one of the things I like to emphasize is that when we talk about the protected classes under Title VII of the Civil Rights Act pertaining to employment, this is the area of disability is one that we all have the potential of entering into for a whole variety of reasons. And so it is really important, particularly for employers, to be knowledgeable about how do you manage these kinds of things. Because as we know, $20 million verdict against Verizon, it's costly. And disability in and of itself is disruptive to individuals, their lives, their families. But again, to lose their employment for reasons that are not properly managed was a whole other thing. You and I both have seen cases where there's back pay reinstated, the job comes back, an environment to go back to work in, but that's the rights.
Mhm.
This is, again, a fascinating subject. Thanks for all your research and work into these topics, and we look forward to the next one.
Yes, it's my pleasure. Yes, happy summer, everyone.
Yes. Folks, if you have questions, if you have some concerns, feel free to reach out to us, and we'll be happy to get back to you. And again, the world of disability is something we might all be in, so it's good to know what our rights and responsibilities are on both sides.
Yes.
Thank you again, Felicia.
My pleasure. It was great to see you.
Yep. Happy summer.
Yeah, happy summer, everyone.